All right. Welcome back to yet another Bree Hive live stream. What is going on, Bree Hive? We are at yet another Thursday live stream. And as I always say, the week goes by super fast. I can't believe how fast the week goes by. If you are watching live, go ahead and drop in the chat and let us know that you're here watching live. If you're watching on the replay, go ahead and drop in the comments. Let us know that you're watching on the replay. And if you're here at all, make sure you hit the like button so that we can reach more friends in the algorithm and we can just have more Bree Hive fun. Okay, y'all. So today we are going to be covering the portion of the case that we were going to cover last live stream, but last live stream went pretty long. So now we're back and we're able to cover Tyrone. Let's not call Tyrone if you have a legal issue because he continuously gets in trouble. And when I say continuously, he has already been sent to, I keep forgetting what it's called every time I try to bring it up, but he was basically sent to a review for the judges because he keeps filing these lawsuits where the court doesn't actually have jurisdiction over the people that are filing. He keeps trying to get diversity jurisdiction so that it is in federal court. I'm assuming so that it's easier to be able to see the documents. And like they said, they're like salacious. They're already, they're always kind of off topic of they wrote a declaration trying to say how this plaintiff knew where their boss lived. And all the while, the whole declaration is talking about this lady and who she's dating and drinking liquor in the office and all kinds of stuff that really had nothing to do with indicating why this guy knew where she lived. So he has done a couple of these things in different district courts and he's already kind of being watched. And I think it was like 6 different cases where he's been an issue. And now he is an issue in this case with who else have we been covering for the last couple of months? Diddy. And this Diddy lawsuit where he sued UMG and all kind of people under the Rodney Jones lawsuit, UMG and their subsidiaries and the people that work with them are coming back after him saying that you owe me sanctions. Now, I've kind of skimmed this case, but I'm not super I won't be able to just talk about it. We're going to read through the case. I don't know if we'll actually go through the affidavit because I believe it talks about a lot of the same things, but I didn't get a chance to read both of them. So there's that. Anyways, Tyrone Blackburn, the attorney for Rodney Jones, in the Diddy lawsuit, also in the lawsuit that we covered on Tuesday, where the lady was suing DJ Academics, and he has a bunch of other lawsuits going on as well. So same guy getting in trouble by different district courts, and this time the UMG and their subsidiaries and everybody is asking for him to pay sanctions, which is basically asking the court to order him to pay money basically for screwing up. And they are also asking for it from Rodney Jones as well. So that's the case that we're covering today. I don't think it's going to be a super long live stream today because we only have this case. But nonetheless, if you are here live, like I said, go ahead and drop in the comments so that we can say hello to you. Let's go ahead and see where we're at with the likes so that we can set the like goal. We're at 14 likes with 15 people watching live. So if you're not one person potentially that hasn't hit the like button, make sure you do hit the like button to help us out in the algorithm and get us more friends. And we're going to go ahead and set our like goal. We're going to be ambitious tonight. We're going to set the like goal at 50 likes for the live stream. If we hit 50 likes, then we get to play our lovely like goal Bossy the Bee animation. And of course, we have Bossy the Bee coming in to introduce, or not to introduce, but to say hey to the Bree Hive. So let's go ahead and have Bossy Bee run by. Okay, that intro wasn't like crazy long like last time, so that's good. And Kimmy reminded me who he got sent to, Tyrone Blackburn, in another case, not this particular case, but another district case. He got sent to the grievance committee because he's out here acting wild. So thank you, Kimmy, for that. Let's see who is here watching live. We got Just Me MD saying, I'm not dependent on YouTube to notify me this time. A member of the channel, welcome back. Well, I'm happy you were able to make it on time because I was a little bit behind, y'all. I was eating dinner. I'm not gonna lie to you guys. Most of the time when I'm late, it's because I'm eating. I schedule these things like maybe 45 minutes after I get home from work. So it's like, get on the stream. So I was late eating salmon and salad, so pretty healthy in my opinion. Smalls, moderator of the channel, saying what up, Bree Hive. Hope everyone is well. Hello and welcome back to the live stream. Nice to have you back tonight. We got Smalls saying, if the title Mina what I think it means, Birdman hand rub, I'm here for it. Sanctions against Blackburn. Y'all, I didn't even know what this man looked like until I looked him up this morning for the thumbnail. So I don't know if you guys recognize him from the thumbnail. I just recognize his name all over these. I like to use the word salacious because that's the word that the court used to describe like the facts and the information that he's putting into these lawsuits. So he likes to use all of these salacious things to kind of get the people going, right? Get the people looking at the lawsuit, saying like, hey, why did you do this to this person? Now, are all the facts accurate or needed in the time that he's putting it in? Maybe not. But yes, we are talking about Tyrone Blackburn in the Rodney Jones lawsuit. He's the attorney for the plaintiff and also the attorney for the plaintiff in a couple of the SA lawsuits against Diddy and now the one against DJ Academics. UMG is asking for the court to to order sanctions against him. So that's what we're talking about today. I don't know if I was super clear about that in the beginning. We got Chantel, a member of the channel. Hello and welcome back, saying hello to everyone. Hi to you. Miss Frosty saying hi, everyone. Hello and welcome back to the live stream. We got Kentari, another member of the channel, saying watching it live. Finally discharged from the hospital, but put permanently on the high-duty painkillers. I don't know if that's a good thing or a bad thing, but I am glad you are doing better to the point where you're released from the hospital, and I'm happy that you're here live. And I don't know, I've said members a couple of times, but your comment particularly reminded me of the members live stream that is coming up. I think we're going to do Saturday. Most people voted for Saturday at 6 p.m. now. I don't know how effective I'm going to be on that live stream because I actually am going to brunch and I'm going to like bottomless mimosa brunch. But, you know, maybe it'll be a Tootsie live stream. I don't know. But I am going to brunch earlier in the day. Hopefully I'm not as mimosa'd out by time we do the live stream, but we're going to do the members live stream on Saturday. I don't know exactly what we're going to cover yet, but you guys will know when I know and it'll be posted. And so for those of you who do not know, here on the channel, if you are a member and if you are of the Bree Hive membership, not the baby larva Bree Hive membership, you can join the live stream and chat with me about all the recent cases or really whatever the heck we want to talk about. We may do some like Am I the A-hole type ones because we haven't done that in a while I don't know if we've ever done that. And I don't think we've ever done that on a members live stream now that I'm thinking about it. But we may do like the Am I the A-hole one because there's not that many good cases coming out lately unless you want to continue to talk about this Diddy stuff, which I'm a little bit over with because it's like it's too heavy. It's too heavy with the essay and everything. So, but anyways, Kentari, I'm happy that you're out of the hospital. Y'all, we will have a members live stream on Saturday at 6 p.m. And like I said, hopefully it's not too tipsy of a live stream. We got Joe W, another member of the channel. Welcome in, saying hi, hello, and welcome back into the live stream. We got Just Me MD, another member of the live stream. Welcome back, saying buzzing in live and sending love from the East Texas, where the weather is bipolar and the pollen is popping. Yes, I knew you were going to say that. Welcome back in. Nice to have you in tonight. We got Just Me MD saying hey to everyone again. We got Morgan Runzer saying howdy, Bree and Hive. Hello and welcome back. I like that last name. Like I've never seen that last name before. It's pretty cool. It's pretty cool. Kimmy Locker saying hi, Bree Hive member, moderator, consultant, paralegal of the channel. Welcome back to the live stream. And y'all know what? Kimmy did her job so good on Tuesday that we didn't even have to find new documents today. So shout out to Kimmy for that. Let's shout out to Kimmy. Sorry if Deacon Fatal is here, but the horns had to be done. I'm sorry about that. Chantel saying Tyrone just dropped another lawsuit with a new victim. No. Are you talking about the one we covered on Tuesday, which was the DJ Academics case? Because if there's another one, I need to get like another one by DJ Khaled on this freaking soundboard. I know I said I was going to update it. I haven't looked into it yet. I need to get another one. You know, when he says another one, Yeah, I'm gonna need to get that on here. If it's other than the DJ Academics one. We got Chantel saying to clarify, new lawsuit filed against Diddy filed by Blackburn with a different victim. Really? Which one is this one? Oh, geez. Don't bring more mess in here, Chantel. Come on now. Savannah Jet saying to Chantel, another seeing Texan. What does that mean? It has been a wild spring. Right. Can we get to the summer? I thought everybody was gonna have like hot girl summers, but no, it's not working out the way that Diddy is. Diddy is making all the hot girls not hot, going through some things at this point. MN Mama saying hello from Minnesota. Hello and welcome in. Nice to have you in tonight. We got Kimmy Locker saying, hopefully you are mimosa'd out for the live stream. You want me to be mimosa'd influenced? Or do you want me to be sober at that point? Because at that point, I'll be back at home. So, the vibes are the vibes. Okay. Okay. So I can't guarantee anything for y'all on Saturday if I am mimosa'd out. Bottomless mimosas are the best. So hopefully I can make it to the live stream. Maybe I should do it next week. Maybe we should not do an intoxicated live stream. Let's see. I need to go and check. Right now I'm trying to check the poll. Not that kind of poll, but I'm checking the poll for the live stream or the vote on the live stream to see what the people actually said. Like, do you guys prefer for the Saturday? I think last time I checked, it was Saturday was winning. So let me double check here. Go into the members tab in our community. We are still leaning more towards Saturday at 6 p.m. So we're going to have a little party on YouTube on Saturday at 6 p.m. So hopefully it goes off without a hitch. Hopefully. Small says, I wish Deeks was here to protect us. I hate the horns too. Gosh darn it. No, everyone can't hate the horns. I love the horns. Kimmy Locker says, nah, I want to intoxicate it live stream. Okay, everybody bring your favorite drinks on Saturday evening. Everyone bring your favorite drinks, okay? It's going to be a great time. Going to be a really, really great time. So anyways, other than that, y'all, let's go ahead and jump into the live stream. If you missed the beginning, I said it's going to be a pretty quick and easy live stream. Maybe not, because maybe I can't read that well as usual. But either way it goes, it should be a shorter live stream because we only have one case that we're covering. And we are talking about Tyrone Blackburn. Don't call Tyrone because he's going to get you sanctioned. So anyways, let's have Bossy B bring us into the next segment. I always cut myself off with Bossy B as if I'm not the one pushing the button. Anyways, Tyrone Blackburn, attorney for Rodney Jones and several other people that suing Diddy, and also the lady, I forgot her name already. We covered it on Tuesday. Akashi. I think I was saying it Akash so that it was easy to say on the live stream. But also the attorney for her suing DJ Academics, he is having a motion filed against him for sanctions because he did something bad. They're basically trying to say that he did something bad. He was not. He was bringing a false lawsuit, essentially. So let's go ahead and take a look at that. We have the Rodney Jones lawsuit against Sean Combs, Justin Dior Combs, Cuba Gooding Jr., Lucian Charge Grange, Christina Karam, Love Records, Motown Records, Universal Music Group, Combs Global Enterprises, and John and Jane Doe's, and then also ABC Corporations. This is the wrong document. That was the wrong document, but this is a memorandum of law in support of the motion for sanctions. We want Blackburn to pay because he put us in this mess, made us look bad, and we had nothing to do with it, is what UMCG is saying, and Lucian Grange and some other people. So let's go ahead and talk about it. Sir Lucian Grange, Motown Records, and UMG Recording Inc. incorrectly identified in the complaint, First Amendment complaint, and the Second Amendment complaint. So we're on the third thing of this. I thought we were only on the second, but yeah, that would make sense. We're on the third one. As Universal Music Group, and I am also misidentifying them as Universal Music Group. I'm just calling them UMG. I guess. they're called UMG Recording. So they're like Universal Music Group Recording Incorporated. That's a long name. Either way it goes, let's go on. Which is not a judicial entity, hereinafter sometimes collectively referred to as UMG, submits this memorandum of law in support of their motion pursuant this code section and the inherent power of this court for orders sanctioning plaintiff Rodney Jones and plaintiff's counsel Tyrone Anthony Blackburn, not putting his whole name out there like that. They're going to call him Blackburn for the purpose of this lawsuit. So don't call Tyrone. I know a lot of you are out there. I'm not hating on you, Tyrone, but you are getting in trouble a little bit. So I'm just trying to warn that maybe it's a little bit I'm just trying to warn the people not to, you got a little bit of heat on you. It's time to calm it down a little bit and maybe like take a break. That's what I'm going to suggest here. Preliminary statement. UMG served its second motion to dismiss on April 24, 2024. We are almost at a full month from that day. And its second motion for Rule 11 sanctions on plaintiff and Blackburn on April 26, 2024, providing plaintiff and Blackburn with a 21-day safe harbor within which to take action to avoid the imposition of sanctions. So the safe harbor, basically they send out a letter and let them know, like, if you don't stop this, I'm going to sue you. But you have to give them the full 21 days to say, okay, I'm going to stop it, or okay, I'm not going to stop it. And in this case, we'll get into it, but Blackburn basically said, okay, I'm going to stop it. If he had let the 21 days go on, then he could be awarded sanctions under the Rule 11. But the UMG is going to argue some different positions for the sanctions because he did beat the safe harbor. He did, pull out after they told him, like, hey, if you don't pull out, there's going to be some serious issues. So that's what the safe harbor is, just to give him time to say, you know what, I'm going to change my mind here. Okay. So where was we at? Plaintiff's opposition to UMG's motion to dismiss was due on May 15, and the 21-day safe harbor period would have expired on May 17th, 2024. Keep those dates in your mind. Thus, despite having filed a complaint, a first amended complaint, and a second amended complaint, all of which were filled with offensively false accusations against UMG, asserting claims lacking any factual or legal basis whatsoever, until the last minute, ignoring UMG's March 4, 2024 written notice of the falsity of the accusations and lack of legal merit of the claims, ignoring UMG's motion to dismiss the first amended complaint and its first motion for Rule 11 sanctions, ignoring UMG's motion to dismiss the second amended complaint and UMG's second served Rule 11 motion by dismissing all the claims and allegations against Grange, Motown, and UMG Recording on May 14th. So did we remember that day? The day where the 21 days would have been over was May 17th. So he just pulled out of everything on May 17th, which basically covered his A, okay? He covered himself, and so the Rule 11 technically doesn't apply at this point, but there are other ways that they can get some attorney's fees here. Plaintiff and Blackburn may be saved by the Rule 11 21-day safe harbor from the imposition of Rule 11 sanctions they richly deserve for their conduct. But they cannot and should not be permitted to dodge sanctions under the court's inherent power and under 28 USC 1927. Now, as something, what's going to happen there is that if he is held liable for these sanctions jointly and severably, or maybe only against Rodney, or maybe only if it's only against his attorney, he's good. But if it's only against Rodney or jointly and severably, which means they both are responsible, but if one doesn't pay it, then the other one has to pay the whole thing, or could be liable for the whole thing. Blackburn will, and I can't say I can guarantee it, but if it turns out that Rodney is going to have to pay some sanctions, Blackburn is probably going to face a malpractice lawsuit, which is one of the lawsuits that he's actually helping somebody with that we kind of covered on this channel because of other issues that he had in the federal courts. i.e. that declaration that I previously talked about at the beginning of the stream, where he was supposed to be telling the court how he knew where one of the respondents lived or one of the defendants lived, but he instead just brought up a whole bunch of other nonsense that had nothing to do with what the court was asking for. So that is a malpractice lawsuit. If it turns out that Rodney is going to have to pay some attorney's fees, Blackburn very well can be facing his own malpractice lawsuit because, hey, as an attorney, we have to analyze these things and figure out if this is a good lawsuit to actually file. So if these sanctions are granted against Rodney, we might be covering a Blackburn malpractice lawsuit by Rodney Jones coming up here soon. So let's go on. Courts have the inherent power to manage their own affairs and to assure that litigants do not misuse the court for their own purposes. While the court's inherent power includes the right to impose sanctions on both parties and attorneys, 28-1927 provides the court with the power to sanction attorneys for the excess costs, expenses, and attorney's fees incurred by virtue of their unreasonable and vexatious multiplications of proceedings. Like we already talked about, he is already in trouble with the federal courts for 6 other lawsuits and maybe even more for incorrectly filing them in federal court. And now they're saying they didn't even have a factual basis to bring it against these 3 defendants. And the court should basically, order sanctions regardless of the Rule 11 not applying. And now remember, we covered on this channel as well, UMG did submit a notice or a letter to the court informing them of Blackburn being in trouble with other federal courts. That's how we got into that malpractice case that he's helping another plaintiff with. So the court, the UMG is doing a good job creating a paper trail saying like, hey, this guy did this on purpose, and it's not just because he filed against us and we thought it was wrong that he filed against us, but he has also done this to several other people in the last year or two. So that's something that's important to pay attention to. I set forth in detail in the accompanying declaration of Donald Zakarin and the exhibits here too. The claims and allegations against UMG were completely baseless to begin with. And remember, Tyrone actually said he didn't have no basis for bringing it in his motion to dismiss, his notice to dismiss. He said that his claims were baseless. Like, he set himself up for failure with this. But anyways, they were completely baseless to begin with and should have never been brought. Plaintiff and Blackburn had no factual or legal basis for any of the claims asserted in the original complaint, the first complaint or the first amended complaint or the second amended complaint. At the very outset of the case on March 4th, 2024, they love to tell us about this incident, before UMG was required to incur virtually all of the more than $450,000 in legal fees, a whole house in legal fees, and expenses they have incurred, plaintiff and Blackburn were put on notice that the claims and allegations were completely false and baseless. They could have dismissed the claims and withdrawn all allegations against UMG at that point, but they did not. Instead, they doubled down, requiring UMG to prepare and file a costly motion to dismiss and to prepare and serve a Rule 11 motion. As of March 27, 2024, before UMG was forced to incur the additional legal fees and expenses it incurred after the date, amounting to some $200,000. Plaintiff and Blackburn were in possession of UMG's motion to dismiss the first amended complaint, and by April 1st, 2024, had UMG first motion for Rule 11 sanctions. Those motion papers made it clear, as did the March 4, 2024 letter, that plaintiff claims and allegations were completely baseless, both factually and legally. But also UMG, everyone that responds to a lawsuit says that you should not have brought this lawsuit. Everyone, we have not covered a case on this channel where a complaint has gone forward and someone did not file a motion to dismiss. So they have the right to try to plead their facts that are sufficient enough to state a claim. They do have that right. Now, did they know that some of those facts were maybe not true? Maybe. But But just you simply filing a motion to dismiss and saying, I'm going to ask for sanctions against you, doesn't necessarily put someone on notice that they're wrong in filing the paper. It's more about them analyzing the case to figure out if this motion is properly filed or not. So just you filing a motion to dismiss, I can't really get behind that. I just can't get behind that because it happens to us in my lawsuits as well, or not my lawsuits, but my cases as well. Okay. Those motion papers made it clear, as did the March 4, 2024 letter, that plaintiff claims and allegations were completely baseless, both factually and legally. Plaintiff and Blackburn could have then dismissed the claims and withdrawn all allegations against UMG, but they did not. Instead, they again doubled down, moving to amend the First Amendment complaint, changing all of the theories of their claims in the First Amendment complaint, and changing the facts alleged in the First Amendment the First Amendment complaint, as if the falsity of the allegations they had previously pleaded was meaningless, requiring UMG to incur some $200,000 in additional legal fees and expenses through the end of April, and additional fees and expenses in May, including the cost of this motion. But the hundreds of thousands of dollars in legal fees and expenses that UMG has been forced to unnecessarily incur are just the tip of the iceberg of the harm that plaintiff and Blackburn's reckless and improper conduct have caused UMG. The salacious, love that word, and utterly unfounded criminal accusations leveled against Sir Lucian Grange, which plaintiff and Blackburn fully understood and undoubtedly intended would be endlessly republished by the press and on social media, including by Blackburn himself, have seriously and needlessly damaged his reputation, one that has been hard-earned by years of service and philanthropy. Indeed, the original complaint and the First Amendment complaint purposefully and unnecessarily included both a picture of Grange and published his home address, requiring Grange to incur additional expense in obtaining security for himself and his family. That's kind of messed up. Yeah, they did put his picture in there. But they also put a picture of everybody else and the logos of the businesses. So, sorry, Grange, you're the only human in this motion. So, yeah, your picture was put up, but I see that Blackburn does like to put pictures in his documents, just like the kind of pornographic photo that was put into the DJ Academics lawsuit. I think it was unnecessary, maybe something that could have been presented under seal, but to put it in a complaint, you are making it salacious. I will have to say that it is salacious. If anything, the fact that there is a litigation privilege should make attorneys more, not less, careful before they irresponsibly file pleadings accusing people of engaging in vile criminal behavior. But that is not how plaintiff and Blackburn see it. Instead, as Judge Coate observed, Blackburn's pattern of behavior is that he improperly filed cases in federal court. They presented this letter to the court already. To garner media attention, embarrass defendants with salacious allegations, and to pressure defendants to settle quickly. Is it a bad strategy? Yeah, it's a bad strategy. Because they've caught on to it. Like, maybe it worked prior when people weren't catching on to it. Now people are catching on to it. And worst of all, the actual judges are catching on to it. So, not a good strategy, Blackburn. We got to do something else at this point. It is obvious that the massively improper actions of plaintiff and Blackburn here are thus not some outlier or aberration. They are instead Blackburn's MO. I would have to agree with them on that. It sounds like your MO at this point, because we're 7 cases deep and you doing similar things. Or no, more than 7. I think we have about 10 cases at this point deep in doing the nonsense that you're doing. And if Judge Coates' referral to the Southern District's Grievance Committee was not sufficient to put a stop to Blackburn's improper conduct, I probably would have pulled out of all cases. Maybe I'm a punk, Maybe I'm a punk because I probably would have pulled out of all cases when they did that. You sending me to the Grievance Committee? What did I do? Well, we know what you did. You don't even have proper jurisdiction to file this case. But yeah, I probably would have pulled out of all cases. But I agree with that statement too. This is a strong paragraph because they have me agreeing a lot. Blackburn's, where was I at? And if Judge Coates Referral to Southern District Grievance Committee was not sufficient to put a stop to Blackburn's improper conduct. Perhaps meaningful monetary sanctions that directly impact his wallet will, and it will. It'll make him stop acting up. I can guarantee you that. One thing is clear, because especially when his client also sues him for the money, if he's found liable, oh yeah, it's over for him. One thing is clear, sanctions in this case are absolutely warranted. And then they're going to go into the relevant facts. So I think I am going to go ahead and check out the comments, because the comments are piling up before we get into the relevant facts of the lawsuit. And y'all, I'm sorry, I skimmed this on Tuesday and I thought I had it all in my head, and it's not. So we are going to go through that part of it, and then we'll get into oh, never mind. I guess the comments aren't too backed up, but that's okay. We'll still jump into the comments to see what y'all think initially, and then we'll get into the relevant facts and then pop back over to the comment section. So Bossy B, where you at? Where did Bossy B go? Oh, I thought she disappeared for a moment. Okay. We got Joe W saying coconut rum for the lit members live stream. Lituation. Kimmy Locker says, yes, Joe W. I'll be right there with you. Coconut, I don't like coconut. Like, I really don't. I'll probably do like tequila or something. Mackenzie Carter Cameron says, laughing my A off, academics looks like he lives in mommy's bed. He does. That's not nice, but it feels accurate. It feels accurate. Let me put the word feels in there. Savannah Jet says, Central Texan. Okay, makes sense. We have had what I consider a lovely spring full of severe weather. We're at the southern end of the tornado alley. So usually not a lot of tornadoes, not this year. Oh, well, geez. Well, hopefully it stays safe for you. Mackenzie Carter Cameron says, it's so hard to keep up with the legal stuff with Diddy. I can't imagine how hard you YouTube attorneys keep them all straight to report on it. I have Kimmy's help. That's what it is. I have Kimmy's help, and y'all see I confuse things at all times. I'm constantly confusing things, but it is a lot going on in these cases. I think this might slow him down a little bit, because he did file like several lawsuits back to back to back, majority of them against Diddy, but he also has some other salacious stuff going on regarding people that are not like in the limelight. So those cases are pretty interesting as well. And we covered one of them on the channel, one of the declarations. So no, it's hard trying to find cases and keeping up with cases. So I think on Saturday, we're going to do something a little bit more relaxed. Kimmy Locker says hundreds of thousands of dollars in legal fees is wild to me. $450,000. I mean, but they are like a recording label plus two other defendants. So maybe that's not a lot of money to them, but that's a whole house. Like, that is literally a whole house. Deacon Fatal says, if you haven't liked the video at this point, it might be a mistake not to. Thank you for that. Yes, of course. Thank you for the reminder. I always forget to say it, but somehow Bree Hive still, shows up. But if you haven't hit the like button, please do. It help us out in the algorithm and help us reach our like goal. Where are we at with the like goal? We're at 30 likes. Shout out to the Bree Hive. 25 people watching live with 30 likes, and our like goal for the stream is 50. So shout out to y'all. Deacon Fatal, member of the channel, saying, I have never been happier that I fall under BMI instead of UMG. I don't know if I'm getting what BMI stands for, because I'm automatically going to body mass index, and I don't think that's what you're referring to. I don't think that's what you're referring to. Thank you so much for the $5 super chat. Definitely appreciate it. Deacon Fatal is in the house, so we can't do the horns anymore. And now I know when Smalls is in the house, we can't do the horns anymore either. But I'm gonna have to come up with a different sound that y'all can get down with, okay? I'm gonna have to come up with a different sound, but thank you so much for the super chat. Please let me know what BMI means, because I'm automatically going to body mass index and nothing else is coming to mind. Okay, we got Chantel saying they spent hundreds of thousands of dollars instead of settling. Wow. They couldn't settle. They had to respond. It's too early to settle. A lot of times when you settle, you admit that maybe you don't have a lot of grounds to stand on, right? So it doesn't make sense to settle at this stage in the case, we're not even at like the motion to dismiss and summary judgment. We're not even there yet. It's literally the complaint. They filed 3 different complaints. They're literally at the beginning of the beginning stages. It doesn't make sense to settle unless you're Diddy in the Cassie lawsuit and you know all of your drama is about to come out. And in this case, UMG, they dismissed them from the case within I guess the case been going for maybe like 3 months now, and they've already been dismissed from the case, but there are still 3 or 4 other defendants that are there. So it would not have made sense for them to settle. And honestly, they would have still paid money to settle. So there's that. Kimmy Locker says to Chantel, why would they settle when there was no legal basis for the claims? Yeah, exactly. Chantel says to avoid bad/negative publicity. It's already out there. That it was going to make them look more guilty if they settled than if they didn't, right? Kimmy Locker says to Chantel, the claims were already out there, so I probably would have fought them too, because people probably would have assumed guilt if they settle. Yeah, exactly. Just like we assumed guilt with the Cassie lawsuit settling in less than 24 hours. Okay. That's insane. And so settling is like, okay, I might be a little bit liable, you know, like when people take plea deals. Okay, you got me on camera, you know, cutting the person's toe off. So you're probably going to convict me for that. Unless you're like some people on First 48 where they're like, no, that's not me. It look like me. It do look like me for real. It do. But also my cousin looked like me. So that's not me. It could be my cousin. So, so in those situations where you know there's evidence against you is when you're going to settle or you're trying to save money to not go through it. Because guess what? $450,000 does sound like a lot to us as average people. And sorry if anyone in the chat is not average monetarily wise. If you're a rich person, appreciate you. But us normal people were like, $450,000 is a lot. We're talking about a record label. That's probably drops in a bucket. They're going to write it off on taxes. It's going to be nothing to them, right? And if they would have gone through the whole lawsuit, they were more looking at spending millions than a little 450. They probably would have spent like tens of millions of dollars, not 450,000. So even though it sounds like a lot of money to us, going through the lawsuit itself was going to be expensive. They have tons of attorneys. Those attorneys are going to be charging close to, if not more than $1,000 an hour. So this money, although it sounds like a lot, is very, very little when it comes to civil litigation with big companies like these. Okay. So I hope that makes sense. Okay. Upside Down says, if I had the money they have, I'd be doing a whole lot more with it than this waste of resources. They got to defend themselves. Kimmy Locker says the Upside Down, I mean, they don't have much of a choice. They had to defend. Yeah, exactly. Kimmy, are you in my brain? Like, what's going on? Had to defend themselves against bogus claims. You're making me feel like I don't have original thoughts and I'm plagiarizing. Like, come on. The Upside Down says, yeah, Kimmy Locker, I just see blessed beyond and no one doing anything substantial for humanity. And again, these are record labels. There's only one individual, but he is pretty much being defended by the record labels. Okay. So we got Kimmy Locker saying the Upside Down. Fair enough. Deacon Fiddle says, okay, line items 76 and 91 are some items that were brought out to me today. Okay, I don't know where that was. 90, 76. This document doesn't have numbers on it. Kimmy Locker says, I'm surprised Stevie J didn't take action over the gay corn claim and screenshot. They removed that so fast, though. They removed it quickly, so he still could. But they, one, litigation privilege, right? Litigation privilege. They pulled him out of it. He wasn't a sued defendant, so he really didn't have a lot of remedy there, honestly. Because litigation privilege, you don't necessarily get sued for defamation because you're trying to plead the facts sufficient to state a claim. And if they're not all the way accurate, discovery will let you know if it's accurate. And when he found out that it wasn't actually Stevie J, they removed it. So there's that. Upside Down says to Kimmy Locker, my goal is getting a license for a hemp farm and having housing on site for employees. Oh, that's cool. That is cool. Kimmy Locker says, love it. Sakatoa says UMG is Universal Music Group Recording Incorporated. They don't want you just to name them as Universal Music Group, but yes, it is. Sakatoa says, I forgot what BMI is. BMI Music Group. Okay. BMI is Broadcast Music Inc. I don't know if I've ever heard of that before, but I'm not super into the music industry, so don't shame me, okay? Small says, nah, it's your stream, Bree. You can do the horns when I'm here. Certainly pitches make the fold of my Nero spicy brain itch if it is a me problem. LOL, don't stop on my account. No problem. Thank you. I like Nero spicy. I like that word. That's a good one. John Smith says Diddy is like, I got the money, just pay these. Where's our beeping? Is that worse than the horns? I'm sorry, y'all. I had to do the sensory. Pay him off. He paid off Cassie. That's it. Gimme Lockett says, cutting the person tail off. Your example is crapping. I don't know where these things come from, Gimme. I really don't. I might be neurospicy myself. I've never gone to try to get diagnosed, but my sister tried to diagnose me all the time, and she's like a special needs teacher. She has a lot of kids with like autism and things. So she says that she thinks we have autism, some form of it. I don't know why she wants to diagnose everyone, but she thinks there's something wrong with all of us in our family, which is interesting, but I don't know. ADHD, things go on in my brain. I can't explain it. They come out and I'm on camera, so you guys get to witness all the weirdness. So I'm sorry about that. Deacon Fiddle, thank you again for the $5. Oh, see, I did it again, didn't I? I tried to change my voice to something strange because I'm on the wrong freaking keypad. So, back to normal. I'm sorry if that hurt y'all ears. Every time I accidentally hit one of those voice changer, it like hurts my ears with these headphones. So I'm sorry if that hurt y'all ears. Thank you again for the $5 super chat. Says, I think the record labels will drop the hammer because of insurance purposes, because insurance is very expensive. And possibly, but also if you're not liable for anything, like just because they may or may not have made a song with you, doesn't mean that we support his freaknik stuff, okay? So I think they were in the right to go ahead and file the, motion to dismiss and say we don't have anything to do with this, which every defendant do. Like every defendant does that. We have not covered a case on this channel where someone did not file a motion to dismiss, motion to strike. Lizzo's appealing because her motion to dismiss wasn't granted. So the defendants are always going to do that, right? Try to get it dismissed before it can get any further. So thank you again for the super chat. We got Kimmy Lockett says, I'm only in your brain a little bit. That for example was all you. Yeah, thanks. Kimmy, what kind of examples? Give me some examples, man. Chantel says, thanks for the explanation. My law degree from Law and Order University is failing. I heard that school got shut down. I'm sorry, but you can possibly get your loans forgiven if they did shut down. I didn't learn that. No, it's okay. That's what this place is here to have fun. There are no, I'm wrong. Well, no, we can be wrong, but don't feel bad if you were wrong about anything. Don't feel bad if you misunderstood things. I misunderstand things all the time, and I'm the one showing my face on camera. Kind of embarrassing, but no, you are all good. Okay. Mackenzie Carter Cameron says, mine too, to Chantel, the degree is failing. Y'all better go get y'all money back. Just Me MD says, then he gonna be like delay. Yep, that's what they're gonna do. Mackenzie Carter Cameron says, laughing my A off. Every family has one of them. The diagnoser. The diagnoser, because you're a teacher. Like, come on now. Can you at least be in the medical field before you start diagnosing me, child? She's the youngest one too. So called SLP, member of the channel, welcome in, saying better than bowling balls, I guess. Not you remembering that. I don't like that for us. I do not like that for us. Kimmy Locker is saying it is, though. The cutting off the toe is a little bit better. Okay, I'll keep it a little more graphic for you. So SLP says to Kimmy Locker, bowling balls would shatter more than a toe, right? Take your whole foot off at that point. Kimmy Lockett says, "Nah, your examples are more fun than any I could give." Okay, I'll keep it. I'll keep with the weird. I'll keep with the weird. It makes the live stream fun, right? We can't be boring on a live stream. Otherwise, no one would come. No one would come and hang out with us if we were boring, right? Okay, let me go ahead and bring us back into the relevant facts before I scroll away too quickly, as I've already done. And hopefully, my reading is not too boring for all the peeps. So. All right, relevant facts for this motion for the sanction as set forth in Exhibit A of Zakarin Declaration. The original complaint and First Amendment complaint both claim that Motown was the parent company of Love Records, and UMG thus had a respondent superior relationship with Sean Combs. So basically, you're their employer, so you should be liable too. Let's see. That was utterly untrue. Yeah. Do your research. Freaking Blackburn, you just got in trouble for this in freaking the Southern District Court. Like, what the heck? Saying someone is like an owner or what did they say it was? A parent company? And they're not. Like, you can literally look that stuff up. Anyways, let's go on. The original complaint and First Amendment complaint also alleged that plaintiff had personally seen Grange at Combs' home in Los Angeles and Miami during trafficking parties, and that Grange and Combs had disappeared for hours into Combs' bedroom at night. I don't remember reading that, but yeah, there's that. Blackburn cut and pasted those identical allegations, not cut and paste, those identical allegations into the original complaint and First Amendment complaint with respect to Motown's former president, Ethiopia Hatemere, I'm not going to say that right, as well. These incredibly salacious accusations were also completely untrue. These patently fabricated, okay, y'all like the little, it's not alliteration, but they're trying to use like super strong language, like repetitively. These patently fabricated and highly incendiary allegations provided the foundation for Grange's supposed knowledge of and alleged involvement in Combs' alleged trafficking. And the equally false parent company allegation served as the supposed basis for implicating UMG and plaintiff's federal civil racketeering and trafficking claims against the Combs defendants under the Racketeer Influence and Corrupt Organization, also known as RICO, and the Traffic Victims Protection of 2000. Before having to spend what would ultimately amount to over $450,000 in legal fees and expenses on March 4, 2024, UMG put plaintiff and Blackburn on written notice that the claims and allegations of the First Amendment complaint were offensively false, and unless they were immediately withdrawn, UMG would seek not only dismissal of the claims but sanctions under Rule 11. Blackburn rejected UMG's demand, reiterating the false accusation in the First Amendment complaint, but Blackburn also made no effort whatsoever to serve the First Amendment complaint, preferring to have the offensively false and destructive allegations remain unaddressed in a public record. UMG blunted this tactic by unilaterally waiving service of process so it could file its motion to dismiss, which it did on March 27, 2024, and served its first Rule 11 motion on Blackburn on April 1st of 2024. Informed by the detailed declarations provided by Grange, Hatemere, Martha Braithwaite, and Mr. Zakarin, and the memorandum of law making the clear allegations that the First Amendment complaint were utterly false and that plaintiff had no legal basis for any claim against UMG. Instead of dismissing the claims, which is exactly what they should have done, plaintiff and Blackburn decided to simply change their facts and their legal theory to keep their claims. In a letter to the court seeking to amend the First Amendment complaint on March 28, 2024, Blackburn completely misrepresented the content of the First Amendment complaint, writing that it supposedly only said that Combs identified Grange and Hatemere to plaintiff, but that plaintiff did not himself recognize Grange or Hatemere or meet them and speak with them. In actuality, the First Amendment complaint alleged that plaintiff himself personally saw Grange and Hatemere at Combs' home, an impossibility as Grange was never there. The proposed Second Amendment complaint thus jettisoned the prior accusation that Grange had personally attended the alleged trafficking party at Combs' home It also abandoned without any explanation the first amended complaint parent company allegation. Instead, the second amended complaint invented an entirely new yet equally false foundational allegation, repeated some 46 times in the second amended complaint. Motown was the general business partner of Love Records. So first they were the parent company, and now they are a general business partner. They work together. In fact, as detailed in the Haptamarian Declaration attached as Exhibit 3 to Exhibit A of Zakarian Declaration, Haptamarian explicitly told Blackburn that there was no partnership, only an arm's length license agreement, which was attached in redacted form to the Braithwaite Declaration in support of UMG motion to dismiss the first amended complaint and the second amended complaint. Exhibit 2 to Exhibit A to Zakarian's declaration. And the license agreement in paragraph 16.11 expressly provided that there was no partnership or joint venture between Motown and Love Records. Blackburn and plaintiff had the license agreement in their possession for 2 weeks before they filed the second amended complaint on April 12, 2024. They knew from Haptamarian and from the license agreement that there was no general business partnership between Motown and Love Records. But because the parent company allegations had no basis and they needed a new foundation for their claims against UMG, they willfully ignored Haptamarian and the license agreements and preserved with their knowingly false general business partnership allegation. And it could be, I'm not trying to defend Blackburn, but it could be that he doesn't understand a licensing agreement. A licensing agreement is like, I give you permission to use this logo, right? But it's not like, okay, we're in general partnership together. If you buy a building, I'm buying it too. It's nothing like that. So it could be more of his ignorance. I need to look up how long he's been licensed, because ain't no way you're this confident just openly filing all this wrong stuff. In his April 8th, 2024 letter to the court, without the slightest factual basis, Blackburn blithely told the court that plaintiff has reason to believe that the license agreement defendants rely on is a ruse and a toothless sham. We didn't read that on this channel. Indeed, in the same April 8th letter, Blackburn admitted he was making up his ruse argument, conceding that plaintiff and he cannot support such position and instead asked that the court allow the parties to engage in limited discovery. Why does he keep admitting to these things in writing? Nevertheless, in the admitted absence of any basis for challenging the license agreement as a ruse based on the newly concocted and knowingly false general business partnership allegation, the second amended complaint also invented non-existent obligations on the part of UMG to supervise and control how Love Records and Combs chose to spend the money paid and payable by Motown under the license agreement. There is, of course, no such obligation anywhere in the law. But in order to keep the baseless claims alive, plaintiff and Blackburn included such allegations as the basis for the claims against UMG in the second amended complaint and multiplying the proceedings unnecessarily. So they basically knew they didn't have a basis, yet they continue to try to add different things in to kind of create a basis, is what they're essentially arguing. They knew that they couldn't prove that there was a parent company, which you should have figured out before filing the motion. And then you went on to saying, okay, well, they have a general partnership agreement. But even then doesn't necessarily give you vicarious liability. And basically what the defendants are saying in this is that they knew all of this before filing the second amended complaint, even if they didn't know in the first complaint, even if they didn't know in the first amended complaint, or the regular complaint and then the first amended complaint. They for sure knew by the second amended complaint, and they continue to go with a false narrative. So there's that. UMG was forced to unnecessarily incur additional legal fees and expenses in moving to dismiss the second amended complaint and serving the second Rule 11 motion. And again, they changed their theory, so they couldn't just use the same motions. Usually when they do like the first amended complaint and the second amended complaint, it doesn't really change that much. But no, they changed their whole theory. So they had to come up with new arguments. However different the theories and facts alleged in the second amendment complaint were from the first, they remain just as offensively false and legally baseless as the theories and facts of the first amendment complaint. The claims against UMG remain completely unfounded. Accordingly, on April 24, 2024, UMG moved to dismiss the second amended complaint, and on April 26th, they served Blackburn with their second Rule 11 motion. The UMG motion to dismiss the second amended complaint showed clearly and unequivocally, as the motion to dismiss the first amended complaint had, the allegations were false and the claims were completely baseless. They said, let me try something else. Let me try something else and see if they try to dismiss me. Indeed, plaintiff and Blackburn persisted with a second amended complaint despite having not only the benefit of UMG's motion to dismiss the first amended complaint and the first Rule 11 motion for some 2 weeks, but having also heard the courts express dubiety at the April 9, 2024 telephonic conference about his theory for the claims against UMG. This court told Blackburn, I'm not hearing anything that would plausibly give rise to a theory that would make UMG liable because they gave him, Combs, money and because they had a deal with respect to budgets and overseeing certain aspects of the distribution agreement, that they had a duty to babysit him and prevent him from doing all these bad things that somehow gives rise to liability on the part of the company. I just don't know any authority for that. Exactly. So they would have to know, like, okay, Combs, we're giving you a budget of $500,000 to spike little girls' drinks. Then maybe there's some vicarious liability, but just funding a project is not vicarious liability for the, not vicarious, yeah, I guess vicarious liability or respondent superior as far as your employer. And honestly, they're still not even his employer, right? They're just giving him money to fund a project. They're not his employer. They just are in a business contract with him, okay? Ignoring this court, ignoring UMG's motion to dismiss the first amended complaint, and ignoring UMG's motion to dismiss the second amended complaint and their second served a Rule 11 motion, Blackburn and plaintiff sat back, allowed the press and social media to continue to blare their hateful and anti-Semitic tropes about Grange that were based on and triggered by the completely false and legally baseless allegations they had placed into 3 successive complaints. Only at the 11th hour before they would be required to file oppositions to UMG's motion to dismiss and before the safe harbor on the UMG's second amended the second motion for Rule 11 sanctions would expire, did plaintiff and Blackburn initiate an effort to extricate themselves from what they had purposefully wrought by seeking to obtain UMG's agreement to a stipulation allowing them to withdraw the claims in the Second Amendment complaint, initially against Grange and then also UMG. Plaintiffs and Blackburn's belated voluntary dismissal of the second amended complaint. So their position is like, we've been telling you, and you've been dragging this out for 2 months. It should have been gone in March. We're in May, and you're just now getting rid of it. After filing 3 complaints making offensively false allegations against Grange, Motown and UMG Records Incorporated, after being served with 2 detailed motions to dismiss and 2 even more detailed Rule 11 motions with the 21-day safe harbor coming to an end and facing Rule 11 sanctions for their conduct, plaintiff and Blackburn belatedly recognized that they needed to do something to avoid sanctions. It being patently obvious that their baseless claims would be dismissed by the court if they did not dismiss them. UMG refused to stipulate to dismissal, which might enable plaintiff and Blackburn to falsely and publicly pretend that UMG had made some accommodations with plaintiff Wara Kappa's stipulation, right? Which UMG did not do and would not do. Instead, UMG advised Blackburn that he should draft a motion. UMG would review his declaration, and if it were accurate, UMG would separately file a consent to the motion. On May 13th, Blackburn filed plaintiff's motion to dismiss all of the claims and allegations against Grange, Motown, and UMG Recording Incorporated, supported by a declaration that was substantially consistent with a declaration that UMG had approved. Oh, they was working together like, no, you need to say I don't have a basis. And he wrote it in there. I don't have a basis. In the declaration, Blackburn specifically, but belatedly admitted that just as UMG had told Blackburn on March 4, 2024, and in 2 motions to dismiss and 2 Rule 11 motions, all the claims and allegations in the second amended complaint against Grange, Motown, and UMG Recording had no legal basis. They had no basis whatsoever. because Blackburn inexplicably characterized his filing as a stipulation, which it clearly was not. The clerk bounced it, bounced it on May, not bounced it. The language used. Leclerc bounced it on May 14, 2024. Blackburn then filed the motion for dismissal, appropriately characterized it as a motion, and UMG filed the declaration of Donald S. Zakarin agreeing to the dismissal with prejudice while specifically reserving UMG's rights. While all of the claims and all of the allegations against Grange, Motown, and UMG Recording Incorporated have now finally been dismissed with prejudice, the court retains jurisdiction to consider and determine the motion for sanction. The harm left in the wake of plaintiffs and Blackburn's outrageous pleading remains. Beyond incurring nearly $500,000 in legal fees and expenses, virtually all of which should never have been required, Sir Lucian Grange has had a successful and well-lived life pendant, been subjected to anti-Semitic attacks in social media, had his home address publicized, and had to obtain enhanced security for his family. This is not some isolated incident for Blackburn. As Judge Coate has found, Blackburn has an established pattern of behavior that delights in making vile accusations against people and even lawyers and law firms that have little to no basis. Plaintiff, it would appear, is his vehicle in this case for the conduct. Plaintiff and Blackburn should have dismissed all of their allegations and claims upon receiving UMG's March 4th, 2024 letter. They should have dismissed all of their claims and allegations upon receiving UMG's motion to dismiss the First Amendment complaint and first Rule 11 motion. They should have never sought to breath life into moribund claims by completely changing their theories and their facts and seeking to amend into a second amended complaint, and then having improperly done so, they should have immediately dismissed the second amended complaint upon being served with UMG's motion to dismiss and second amended complaint and second Rule 11 motion. Okay. But they did none of the above. Why? Because plaintiff and Blackburn must have conceived it to be in their interest to allow a completely false and baseless pleading remain publicly available as long as possible, no matter the harm it had already caused and would continue to cause. They clearly made a judgment that they would wait as long as possible and then dismiss their claims and allegations before their safe harbor under Rule 11 expired. And the thing is, it's already out there, right? But Rule 11 is not the sole tool that this court has available to address and remedy the purposeful misuse of the judicial system by people like Blackburn, who are armed with a license to practice law, but who have demonstrated again and again that they should not have that right. Don't let him lose his license. This court should award sanctions against both plaintiff and Blackburn in amounts that recognize both the cost that UMG has unnecessarily been forced to incur and the harm that the conduct engaged by plaintiff and Blackburn has caused and will cause if not deterred. So basically stop them from doing it. It then goes into the case law as to why the sanctions should be granted nonetheless. Although Rule 11 doesn't apply, there are some other bases for granting some type of sanctions, and they're probably wanting at least the amount that they spent and then a little bit more to stop Blackburn from doing this again in the future. So that's where they're at there. I'm going to go ahead and shift over with Bossy B and jump into the comments. Okie dokie. Let's see what the comments have to say. But before we do that, let's see where we are with the likes. We are at 41 likes, 31 people watching live. If you haven't hit the like button, please do. Our like goal for the stream is 50 likes. So we are only 9 likes away from hitting our like goal for the stream. I see with my little eye, I can't pull it. Oh, I can pull it up. Deacon Fatal gifting 5 Boss Attorney Breed memberships. Thank you very much. Yes. So welcome to all the new members. That means you can join us on Tipsy Saturday. I don't know if we should promote it as that, but it will be a members live stream. Thank you, Deacon Fatal, for gifting 5 Boss Attorney Bree memberships. I definitely appreciate it. Mackenzie Carter Cameron says, yes, the internet doctor. Yes, the internet doctor. Kimmy Locker saying, when I got my psychological science degree, so many professors told us not to diagnose people we know. They said we'll see stuff everywhere, but had to resist the urge. LOL. Yeah. Yeah. It needs to be focused on more. Okay. Just Me MD says the best thing I learned from my psych grad was that we are all crazy. That's just how I feel. I feel like there's something wrong with all of us. You know, it's just not normal to live here on earth, in my opinion. We're all crazy, some just a little more than others, right? You just gotta gauge your crazy, right? Kimmy Locker saying true. Just Me MD says, oh, I thought they meant the TV show Law and Order. I'm like, mine was failing too, so I went to YouTube University for law. That is what they were talking about. That's what I thought they were talking about, was the Law and Order show. Yeah, YouTube University is straight too. That's straight. I don't think they've been shut down though. So Law and Order University is probably shut down, but I think YouTube University is still standing strong. Chantel says, yes, I meant the TV show. Okay, yeah, I was like, that's what I thought she meant. Small says, to me, Black and Sync stream last night was about being neurodivergent and Black. We had 3 Black women films and Kimmy on to discuss. Might give you some real life insight if you think you may actually be a brain. What is that little other thing? But I mean, I can go get diagnosed. I don't know. I guess it's not that big of a deal to just go try to figure out what's going on in your own brain, right? So, I mean, I might do it. I mean, I probably should. My sister says it. I don't believe that girl, but it is what it is. The chili pepper. It was a chili pepper for the spicy. It's white on my end, so it doesn't look like a chili pepper. So I did not know what that was. The way that the graphic is showing up on my end. Deacon Fatal says they seem very brazen with their filings. In regards to who? Destined to be also known as Tiny D. Welcome in, saying yes, they do. I don't. Who are you referring? Were you referring to the defendants? Kimmy Locker says to John Smith, love professional snark, love it as always. Again, thank you, Deacon Fatal, for the Boss Attorney Bree memberships. Destined to be Tiny says, are we drinking? For the members live stream, apparently it's gonna be a lit stream. It's gonna be a lit stream. Okay, so apparently that's what we're signing up for. Bring your favorite cocktail, your favorite beverage. Don't take straight shots back to back on the live stream. I don't know if we can do that, but yes, you are welcome to have a little sippy sip as we chat. I think we're gonna do Am I the A-holes for the members live stream. Now, I did not really go over the declaration of the attorney, so I don't really know if it's worth covering. I think it's going to talk about the same things that they repeated over and over and over. Yes, you guys filed a motion to dismiss the First Amendment complaint, and then you filed one for the Second Amendment complaint. Come up with something new. Like, I get it. Maybe they should have, okay, yeah, Kimmy agrees that it pretty much says the same stuff, which is what I figured. Sure, they should have dismissed it, but also maybe they just thought they had a claim. But I mean, at this point, after filing that letter with him getting in trouble with the grievance committee and another federal district court, he probably did know. I would say he probably did know. That's my opinion on the situation. But just filing a motion to dismiss or saying I'm going to get you for sanctions, it's really not a basis for somebody then to pull out of it. Maybe like a letter, like showing them like, hey, no, we're not a parent company. We were formed in this year. And then this company was also formed in this year. So there's no way we could have been a parent company. Maybe something like that. And that lady telling them, I don't live in freaking New Jersey. What are you talking about? Or I don't live in New York, or whatever one they were trying to say she lived in, saying that she didn't live there. Now, that one was a blatant disregard. And if he did it with that lady's address, you don't think he's going to do it with some sneaky, allegedly sneaky recording studios and all of those, like just trying to hide and be shell companies and potentially be shell companies. You don't think he's going to do that to you if he did it to a whole person saying, hey, I don't live at my office. That one was pretty obvious. I don't live at my office, sir. I live in this house over here or this apartment over here, not my office. Like, what are you talking about? But yeah, just filing a motion to dismiss or a motion for sanctions is not grounds for you then to pull your document. You don't know how many times people in family law threaten sanctions, and they rarely get ordered. Okay. You have to be doing something outrageous, to get sanctions ordered against you. So y'all, it was a little, pretty quick live stream today. I don't have really much for us to go over anymore. I don't want to read the declaration because it's going to be talking about the same thing. And I guess we're only an hour in on the live stream. I thought we was going to at least make it to 1:30, but we're not doing anything else. We're going to tap out for the night. I hope everyone has a wonderful 3-day weekend, and I will see y'all on Saturday on the members live stream. If you are a member at the Bree Hive level, you will get a link to join into the live stream. Just make sure if you're joining into the live stream to chat with us that you have on headphones, and you have your favorite sippy drink. For the people in the chat that just wanted a sippy drink with us in the chat, that is completely fine as well. The reason for the headphones is to kind of cancel out some of the noise cancellation. And Kimmy, I'm calling you out. Make sure your mic is not doing weird things. I'm sorry. I didn't have to call you out like that. I could have texted you privately on that one. But no, for real, it's all good. We are always able to fix any sound issues and figure it out from even if we're live, we'll figure it out. And feel free to join in a little bit early. I'm gonna try to log in early for the live stream so that we can kind of chat before the members live stream. For those of you that just want to chat, I'll try to sign in like 15 minutes early. So around 5:45, I'll start this. I will be backstage in the stream. And then for anyone else that wants to join in and chat before we go live, we can do that. And like I said, we're going to be covering some Am I the A-hole? So it'll be very light. We don't have to talk about any of these heavy cases that we've been covering. And I have been rambling. So with all of that being said, I will see y'all all on the next live stream. I hope everyone has a good weekend, and I will see you